just have them hear it. And then when it's
Okay.
over, then Shireen will take the lead and hopefully we'll get a discussion on, you know, the many ways you can do this.
Okay. All right, letting everyone in now. Okay. Just letting the last few members in. Looks like we're good to go. Good evening, everybody. Welcome to the February 2021 Barney Masterson Inn of Court membership meeting by Zoom again. Maybe one day we'll be back to in person, but not yet. So until then, here we are. Tonight, we are doing a presentation on opening statements that's going to be presented by Bob Persante and Shireen Vesley. But first, just a few announcements. Let's see. Okay. So just as a reminder to everyone, in case you ever need to get a hold of anybody in the inn, on the board, if you have questions about what's going on, if there's an event that you thought was coming up but you haven't heard anything, or really just any kind of questions, if you have another organization that you're a member of that would like to collaborate with our inn, you can email us at barneymastersonin@gmail.com. Try to make it nice and centralized for communications. So just a reminder that you can always contact us there. Next month, unfortunately, it does not look like the Barney BQ will be able to go forward. We haven't completely scrapped it for the year, but at least for when it's traditionally been held, which is in March, it doesn't look like it will be happening on the date that we had previously scheduled. However, as requested, please do not cancel that date on your calendar. We are going to meet. There will not be a CLE presentation on that evening. However, we will be having everybody break out into their pupillage groups, and there will be some directed discussion within those groups. So we look forward to everyone coming at that time. You can have your favorite beverage of choice with you and pretend that we're in person having a great happy hour. But we will be meeting still in March on the 25th at 5:30 via Zoom, just in smaller groups. If you have any questions about that, again, feel free to email us at barneymastersonin@gmail.com. I want to take a moment to thank the judges that are here tonight. We've got Judge Burgess, Judge Reba, Judge Coleman, and Judge Samatovich. So thank you all for coming tonight. And just a reminder to everyone, when watching the initial part of the presentation, it's probably easier or best to watch it in speaker view. We will be doing a screen share where there will be a video for the first portion, but when it comes to the discussion portion after that, initially between Bob and Shireen, it'll probably be easier to see them if you have it on speaker view. And then when there's more discussion with the group, you can change it, you know, to however else you like, but just for ease of use, just a suggestion there. But tonight, like I said, the presentation is on opening statements. We've got Bob Persante, who has pre-recorded an opening statement in an actual case that he's had before and is now resolved. After the meeting, I will be sending out a copy of an opinion from that case. It was in federal court in the Middle District. And it gives a little more detail as to the backgrounds, the details as to the background of the case, timeline, more specifics, which Bob will probably get into some of that tonight. But some of the issues that were attempted to be resolved before the case did end up eventually going to trial. And with Bob, we have Shireen Vesley, who will be essentially moderating a discussion with Bob to discuss with him, the whys, hows, whats of his opening statement, so that we can learn a little more about strategy, how to approach it, why you would say or not say certain things. But that is what tonight is about. And then, of course, as always, we welcome any input or questions or comments from the membership. The chat is open and active. And so if at any time during the opening you have a thought that you just want to throw out there, put it in the chat, and we'll address it once the video is done playing. But other than that, it'll just be open, discussion once we're done with that portion. So if there is nothing else, let's see. Trying to not show you guys all the stuff all over my computer. We will go ahead and begin the presentation. So
thank you, Your Honor. May it please the court, ladies and gentlemen of the jury, I have the honor of representing Olga. She's 92 years old. And we are here today because her granddaughters followed through with their father's plan to get control of her money. And we're here today to try and stop that. There's a piece of literature, I forget the name of it, but it starts this way, that happy families are happy for the same reason, and unhappy families are unhappy for different reasons. In this particular case, the family is unhappy because of grief, but it is also unhappy because of greed. And as we go through this, I will show you exactly what they did, exactly what the defendant's plan was, and exactly how they followed through on it. Now, all of this greed was directed at their grandmother's wealth. Let's meet Olga. She was born in 1923. She was raised in New York. She was the second of 9 children. When the child who was born before her passed away, she then became a second mother to the rest of her children. And when World War II came, she became a nurse. And after the war was over, she married the love of her life, Joe. She and Joe had 2 children, Robert and Joe Jr. Joe Jr., being the older one, is the father of the 2 defendants. Once Olga and her husband saved up enough money, they took their 2 boys and moved down to Florida and bought a motel on the beach. They had that motel for over 50 years. That's where the boys were raised. When Joe Jr. was old enough, he left. He went and became a pilot, meaning an airline pilot, and then he met a woman with money in Oklahoma. He moved to Oklahoma with her, and then in his retirement, they bought a jewelry shop in the mall, and that's where they live. While they're in Oklahoma, of course, they then have the 2 children. Those 2 girls, every single summer of their lives, went to stay with Olga at the motel. Olga and her husband Joe and their uncle Robert. When they hit 25, they went to law school, they became attorneys, they stopped coming to the motel. Who stayed at the motel? Robert stayed at the motel. And Robert worked at the motel his whole life. And his father, Joe, used to say, Robert, you've been here with me the whole time. When I sell this motel, you're going to get half of it. You're going to get half of the motel. One day, Joe has a stroke. And it's a bad stroke. And when he has that stroke and he's recovering, who comes down to visit is Joe Jr. Joe Jr. flies in from Oklahoma to meet with his father, and he says, Pop, you're not in good shape. We need to sell the motel. And the split is going to be a third to my brother Robert, a third to you, and a third to me. Pop agrees. There's a problem with Pop agreeing. Actually, there are two. The first is he's always promised Robert that Robert's going to get 50% of the proceeds from the motel. The second is that when Joe bought the motel, he borrowed money from his brother Nick and said he would pay him back with interest when he sold it. So Joe says to Joe Jr., what about my brother Nick? No, I owe him a small fortune now. And Joe Jr. says, I'll take care of Uncle Nick. I'll file a lawsuit against him up in New York, claiming that he promised us some of his properties. Then he'll file a claim against us. I'll find a way to wash it out and get rid of his interest. Joe Sr. says, okay. Robert says, I'm out of here. I don't want any part of this. I'm not doing that to Uncle Nick. So Robert leaves and never speaks to his father again. And true to what he said, Joe Jr. then goes up to New York to start this mess, this messy litigation. While that litigation is going on, Joe dies, the father dies. Now Olga is in the deepest state of depression. She's lost the love of her life. The motel finally sells, and he's not there to enjoy a penny of it. She's all alone. She asks Robert to move in with her, and he does. Robert had had his own family. Robert had been married. He had 2 children. Marriage was long over. Robert moves in to take care of his mom. What happens in New York now is that it gets worse. When Joe Jr. realizes that he's really got no way of getting rid of Uncle Nick's claim against the proceeds of the motel, he claims to the court that he has a promissory note for $250,000, that he had lent money to the motel and that the motel owed him that money as a priority, and that there were other debts and expenses with the motel, so that when the sale went through, there really wasn't much of anything to divide up. And the problem with what he was saying is that it was all completely and totally false. Joe Jr. never had anything to do with the motel. He was a pilot and later ran a jewelry shop. Joe Jr. never lent any money to the motel. Joe Jr. never had a single thing to do, never ran it, was never there, never fixed it, didn't have any sweat equity in it, didn't have anything in it. So as you can imagine, what happens up in New York is that the lawyers for Uncle Nick say, where are the documents? Show us the note. Show us the receipts. Show us the expenses. Show us why there's no equity in this. Show us why we get nothing. And of course, Joe Jr. can't produce any of that. He comes up with an Excel spreadsheet with an amortization table to show, that he had lent money and how it was being paid back over the years, but an amortization sheet is just that, something that he created and not a signed promissory note. So because he stops turning over documents in the New York court, the other side moves to compel. That is, they go to the judge and say, Judge, we're entitled to this. He needs to give it to us. He won't. The judge orders him to produce the documents. He doesn't. Finally, the judge issues what's called an order to show cause. That is, we're having a hearing on this day, and you have to show up and give me an explanation as to why you shouldn't be held in contempt of court. So Joe's thinking, what am I going to do now? What am I going to do now? Figures it out. I need something to back me up. I'm going to get my brother Robert to sign an affidavit that, number one, I was owed the money by the motel, and number two, that he's the one, Robert's the one, that kept the books and records, and he's lost them, mismanaged them, you name it. So he sends an affidavit down to Robert to ask Robert to lie for him. Robert gets the affidavit. He reads it. Calls his brother. He says, I can't sign this. None of this is true. I'm going to get in trouble up in New York. And I told you before, I don't want any business. I don't want to have anything to do with what you're doing to Uncle Nick up there. Joe is angry. But to buy himself time, what Joe says in the New York court is that my brother has signed an affidavit that'll prove everything that I've told you. I'm just waiting for it to show up. But then what happens is Robert's cousins call him. Uncle Nick's kids from New York call him. And they say, Robert, your brother's up here saying that you signed an affidavit and that he lent money to the motel and that you've got all the receipts and you've lost them, or, he's got a bunch of different excuses. Robert says, no, I never signed an affidavit. I don't want to be involved in that. So, well, Robert, you have no idea what your brother is doing to our dad. Would it be okay if our lawyers called you up? Because this just isn't right. And Robert doesn't want to be involved. But he says, sure, they can call me. And the lawyers call him up. And they find out what the cousins had just found out. And that is that Joe Jr. was lying to the court, that there was no affidavit, that there was no loan, that there weren't all of these receipts and documents to prove that there were no proceeds. Now, Joe Jr. is furious. Because the lawyers are in court in New York telling the court about their conversation. And then worse than that, they get Robert to sign an affidavit telling the truth. When that happens, what the court does at that point is enters what's called a default. So Joe Jr. is up there defending that case, and the court enters a default against him. For $1,054,000 in sanctions and damages, and for perpetrating a fraud on the court. Joe Jr.'s got the money to pay it, but he's got another idea. He's going to go down to Florida and convince Mom to go to Oklahoma with him. And then get her there and change her estate plan so that he and his daughters are the beneficiaries upon her death. So that whatever he has to pay in this judgment, he's going to get. And the other benefit is Robert won't get a penny. He shows up in Florida and he says, Mom, you're grieving. I know you're sick to death over what happened to Dad. We're all upset. And I know you love this place and this was your home with him. But how about you come to Oklahoma with me? The girls are there. They're both doing well as lawyers. My wife loves you. You'll be with us. Change the scenery. Just temporary. Change the scenery. Come to Oklahoma with us. And she says, you know, maybe it would be good. I'm pretty down. I'm pretty down. While he's talking to Olga in her apartment, Robert's son-in-law, Jeff, shows up. And Joe says, Jeff, can I talk to you in Mom's bedroom for a minute? Sure. They go into the bedroom, and Joe Jr. is right up against them and pointing his finger. And he says, okay, I'm really angry with my brother, and I'm not going to give you the full language. You'll hear it from the witness stand. I'm really angry with my brother. And he pulls out the judgment. He's got it folded over. It doesn't show that he, for multiple contempt and sanctions and all of that, it's just got the number, $1,054,000. And he says, Robert did this to me. Robert did this to me. You tell my brother I'm gonna butt F him as hard as I can. And Jeff goes, whoa, wait a minute, Joey, hold on, calm down. Joey says, I'm not calming down. You tell him I'm gonna butt F him as hard as I can. You watch. And then Joe comes out to see his mom. Mom, let's get you packed up. We're gonna go to Oklahoma. And she goes with him. She flies to Oklahoma. Before she goes to Oklahoma, and this has been her condition for years, and of course it didn't get better in Oklahoma, Olga is legally blind. In her good eye, okay, her vision is 6/200, which means that what you could see from 200 feet away, she can see from 6 feet away. She has to be 6 feet away to see something that you can see from 200 feet away. Her other eye has a blockage, so even with corrective lenses, she can't see from it. In addition to that, she's got serious hearing problems. You have to yell, even though she's got hearing aids, they cannot fix the problem that she's got. so she can hear a little bit, but you've got to be really loud with her. As far as her eyesight and her ability to read things, in Florida, she's got a big machine like this, and she can put a document on it, and it's got a light overhead, and it magnifies things. She can read it. She doesn't have that in Oklahoma. So she's in Oklahoma a couple of weeks, and Joe Jr. says, you know, Ma, you're getting up in age. Dad passed away suddenly. I want to take you to my lawyer. You need to get things in order. It's really to protect you. And so Olga goes to the lawyer's office without being able to read, with difficulty in hearing. And they get her to sign what's called a revocable living trust, leaving all of her assets to Joe Jr. and his kids, and leaving nothing to Robert and his kids. Now let's talk about what a trust is, because it's really relatively simple. I think of a trust as a box, a banker's box, and you can put whatever you want into that box. You create a trust, you put the assets into it, it's got a lid on it. If it's revocable, you can take the lid off, you can take the stuff out, you can get rid of the box. You can change it, alter it, amend it, revoke it. It's your box. So at this point, Olga has signed the document. She doesn't know what she signed, and it's never discussed. She doesn't get any copies of it in advance to know what she's going to be signing, and she doesn't get any copies of it after she signs it. She's then taken back by Joe Jr. to the house, and life continues to go on. And then, as fate would have it, Joe Jr. dies. And now Olga, who has left Florida to get away from the grief of her husband, get a change of environment, is now in Oklahoma, and now her son is dead. The whole household is upset. The granddaughters are upset, their mother's upset, Olga's upset. And another thing's going on, Olga feels uncomfortable there. They've changed towards her now. They are not as friendly with her as they were when Joe Jr. was around. Now she's an annoyance. They say things to her. Grandma, you can't see, you can't hear, you can't walk, okay? Stay out of the kitchen, you're gonna burn the house down. They don't really have anything to do with her, and she senses that, and she wants to get out of there. So she tells him, look, I miss my house. I want to go back. I came here to get away from Joe's death, and now I got Joey's death. And so I got to go home. Now, that's a problem for them. They're lawyers. They know that she has created a revocable trust that can be undone when she gets back to Florida. Stuff can be taken out of it. So what are they going to do? They say we got to go back to the lawyer's office to straighten out a few things before you go back to Florida. They pack her up and put her in the car, and they go to the lawyer's office. At the lawyer's office, she sits in the lobby. She never goes back to meet with this lawyer. This lawyer who is their friend, who is the family lawyer. She never, ever meets with the lawyer. The lawyer never explains anything to her. Olga's sitting in the waiting room. She doesn't know what's going on. Just like right now, she cannot see you. You're too far away. She can make out some colors, but she can't see you. She's sitting in this waiting room, not really able to see anything, waiting to get called in. She never gets called in. They take her home. They put her on a plane. She flies back to Florida. Now she's with her son, Robert. And she loves being with him. Now, she'll tell you that I love being with Robert, but I'm a girl and I like to talk a lot, and he doesn't like to talk so much. But she loves being with him. And Robert is what, obviously Olga's Italian, what they call in Italian, a piece of bread. That's someone who gets along with anyone. That's Robert. Robert could stretch a $20 bill a whole week. He fishes, smokes some cigarettes, drinks some beer, takes care of his mom. That's his whole life. Very simple life. When Olga gets back, she says, Robert, let's go to the bank to get some quarters to do laundry. She lives in a condominium, and in the basement they have the laundromat, and it's a coin laundry. So they go to the bank to get the coins. They have to do a withdrawal to get the coins. She goes up with the withdrawal slip, and the teller says, I'm sorry, Olga, you don't have access to this account anymore. What are you talking about? That's my account. Sorry, Olga, you don't have access to this account anymore. So Robert says, Ma, did you do something in Oklahoma? Did you sign something? She goes, they got me to sign something. I don't even know what it was. Well, let's go back to the house. Before they go upstairs, Robert goes to the mailbox. You know, they each have their own mailbox in the condo, uses the key, opens it up, and there's a card from the Department of Motor Vehicle. And he looks at it, and it says that his dad's car is now in the name of a trust. He says, Mom, did you change the title? Did you put Dad's car in a trust? She goes, no, that's your father's car. Robert says, look, I'm going to call Jeff. You know, Jeff's a stockbroker. Let's see what Jeff says. He knows this stuff. So Jeff comes over, and he refers to, of course, Olga as Grandma. He says, Grandma, did you create a trust when you were in Oklahoma? It looks like you might have done that. She goes, I don't know what they had me sign there. Well, do you have that? Do you have any papers? They didn't give me anything. They didn't explain anything. They didn't give me anything. So Jeff calls up Teresa, one of the granddaughters. Hey, can you tell me what's going on? Grandma can't get into her bank account, and her car is now in, we got a card from the motor vehicle saying that the car is now in trust. And Teresa says, call her lawyer. You'll have to talk to her lawyer if you want answers. So Jeff says, who's that? Gets the name of the lawyer, calls the lawyer up, and the lawyer says, yes, she had done a revocable trust, and then she did an irrevocable trust. She made it irrevocable right before she left. And the granddaughters are in control of that irrevocable trust. So we talked about a revocable trust. You can take off the lid, you can take everything out. An irrevocable trust, that lid is locked, and only the trustees can unlock it and open up the lid and put anything in, take anything out. The people that hold the key to that lock are the defendants, the two granddaughters. So Jeff explains that to Olga, and they go see a lawyer, and the lawyer sends a demand letter out. Please undo this trust. Help her to undo this trust. This is not what she wanted. She didn't understand what she was signing, and she's lost total control over her assets. Lawyer says, I can't help you. It's an irrevocable trust. be undone. So Jeff and Robert said, well, let's put Grandma on the phone with Teresa. They called Teresa. Teresa, can you talk to Grandma? Grandma on the phone. And she says, I don't know what you got me to sign over there, but it's not what I want. I can't even get money out of the bank. I have no control over anything. I want all of that undone. And Teresa says, no. No, you signed it. It's irrevocable. That means that that's it. And now we're in charge and we're going to be in control and take care of you. Pay your bills, decide what money gets spent on what. The conversation ends. What we then noticed about this signing of documents that happened in Oklahoma is, recall that the first trust that was done was the revocable trust that Olga could have simply undone once she got back to Florida. But the second trust was irrevocable, meaning it could never be changed or altered. How did that second trust ever get signed? And the answer is it did not. When Olga went to the lawyer's office the second time, right before she was going to head back to Florida, brought there by the two granddaughters, and where she's sitting in the waiting room and never meets with the lawyer, what she didn't know was that in the back room with the lawyer and the two granddaughters, again, both lawyers, they had created an irrevocable trust, and then they took Olga's signature from the revocable trust that she had done more than a month before that, and simply took it and attached it to the irrevocable trust as if she had signed that irrevocable trust a month ago. So when we say that an irrevocable trust cannot be undone, that's true, except in a court case. And so I have had the honor of working with Olga and carrying her through this process. And as you go through this case, it'll be coming to you in bits and pieces, like chapters in a book, except that those chapters won't be in perfect chronological order. But the most important thing I want you to hear is that in the end, you get to write the last chapter in this book. You get to decide whether Olga gets to undo what her granddaughters have done, or whether she's stuck with it. Having gotten to know you a little bit, having at least talked to you for a few minutes in jury selection, I know that she's in good hands. Thank you.
Good job, Bob.
Thank you.
So I think,
You know, it's always awkward trying to speak to empty chairs.
yes, they don't give you much eye contact. Oh, well, very good, very good. Well, I'll just get started here. There's so much talent in our Zoom room here. I really think that this should be something that's collaborative. So please chime in, whether you just chime in and unmute yourself or chat or whatever's comfortable. Everybody's got their own tips and techniques. You know, I have a few that I've seen and I'll share with you. I guess what I would first say is the first rule is if you're going to do an opening statement, don't find yourself doing an opening statement against Bob. That's number one. Bob is a great storyteller, and the storytellers seem to really have an effect, I think, on verdicts, especially, you know, if you're the one to go first. And so what you saw Bob do was tell the story, a chronological story. And the purpose was at the end to make you feel like you should be the champion for Olga and do what she couldn't do when she called her granddaughter on the phone and asked her to undo this trust that she didn't know she signed on to. And so if you're on the plaintiff's side and you tell the story and you empower your jury to take this on, take
Mia,
this cause on.
Daddy's gonna turn it on for you. People, Mia.
So I think, you know, that's obviously the goal when you're the plaintiff. And so clearly Bob's technique was to do this chronological storytell opening, and that had you there. The images of being in the lawyer's office, being in Oklahoma, being in Florida, being at the motel, that all helps to tell the story, the images, the placement of the people and their words. You know, when Bob tells a story, he actually uses the words of the people. And it's more engaged, it's very engaging that way. You know, he has Teresa on the telephone telling her grandmother no. You know, of course he has the comments that Joe made for Robert about what he was going to do to him because he got this judgment in New York against him for over $1 million. You know, those types of quotes and using the words of the people, I think really helped the jury to be there. And of course, you don't know what kind of jury you have until you do jury selection. And if you're doing jury selection in federal court, you probably still don't know because they only give you like 15, 20 minutes to pick a jury, and which is almost nothing. But, you know, when you do pick your jury, you have a sense of the experiences of your jurors, right? You might have jurors who have no idea what a trust is. And Bob does a great job of simplifying that and making it understandable. You know, and this is not an easy case to make simple. You know, we've got a default judgment, we have, you know, a promissory note, amortization sheets, things like that. You know, you have to know your jury. Can they handle those words or can they not? Do you need to make that simple? Certainly the trust was made very simple and understandable. And so I've always liked the storytelling opening statement. And I think Bob does a great job with that. Now, in the very beginning, of course, he kind of told the jury what he wanted. He wanted the jury to undo what happened. And then in the end, he came back around and told the jury that's why he was there. And I think that was very empowering. So I think what I'd like to do is spend a little bit of time speaking with you and engaging you on what should a defense lawyer do in response to an opening like that. You know, what you have is a story that's been told start to finish. You've got a jury who now has probably accepted that as true. So what you say that could be contrary to that is going to, you're going to be, hitting a bit of a wall there. So what do you have to do? There's some techniques that people use, and I know there's techniques that people use that are right here in our Zoom room, and they should share them. But one is combat it with your own story. There's two sides to this case. And here's the other side, and tell the story. Another thing that can be done is take it issue by issue. Bob Persante just told you that the granddaughters did X, Y, and Z, but what he didn't tell you was A, B, and C. He told you this, but he didn't tell you that. He told you Robert's a piece of bread, but what he didn't tell you is about Robert's greed. And you can go into something like that. So I've done that in opening statements just to remind the jury there's two sides, that what you just heard is not everything. What you just heard was a spin for their side. And here's some things he didn't tell you. And it kind of brings them a little bit back around, maybe with more of an open mind and understanding that there's two sides of this thing and they need to keep an open mind. Another thing that I know defense lawyers do, and I try to do it when I'm defending, I don't find myself defending cases a lot, but when I do, I ask the jury, I just ask them in jury selection, and I ask them again, please keep an open mind about this case. Please don't prejudge it. Please withhold your judgment until you've heard all the evidence. What Bob Persante says, what I say, what the lawyers say is not evidence. Withhold your judgment until you've heard from the people who take the stand. That's another way to help with that. And on the defense side, of course, you're not doing your job unless you talk about the burden of proof. Whether it's, criminal case or a civil case, I think it's important to spend considerable time on the burden of proof. Walk over to the plaintiff or the prosecution side of the courtroom, tell the jury, this is the burden they have. My side doesn't have this burden. This is the burden they have. They have to prove to you these things, and they have to prove them by the greater weight of the evidence, clear and convincing evidence, whatever it is. And I like to pull some words from the jury instructions that make that burden sound pretty substantial. So they know they've got to hold them to that burden. And I think it's important to ask them to do that. One of the things that a lot of lawyers nowadays especially do is a PowerPoint or some type of technology. They flash up pieces of evidence on the screen. I watched the part of the Hulk Hogan opening. They were flashing up, some news clips even to the members of the jury. And it's a very common thing now. And sometimes, people say that it's important now to keep jurors' attention with technology. And I say you have to do what fits you. If that helps you tell your story and that makes you have a more confident, better opening statement, then you should. If you're a great storyteller and that doesn't make you feel comfortable, then don't do something that doesn't make you feel comfortable. But I've seen the technology and the PowerPoints and all of that work very, very well. Pictures are 1,000 words. If you have a nursing home case, for instance, and we're talking about a bed sore that should have never happened, there's a time to show that. It may not be an opening, May just be, later on in the evidence, but, if there's particular issues in the case where the photo tells the story, it might be the time to do that right in opening. And so those are some comments that I have, but I would love to open it up and please have, people share what works for them, what observations they had about Bob's opening, so we can, learn from each other.
I had a thought or comment. I guess I would say, as on the defense side of it, I would think, okay, I've got a document with a signature on it. I've got a physical thing, and I've got, I think, the burden of proof in my favor. And that's where I would go with my opening statement. And I was wondering if Bob, I know Bob has, his style is conversational and storytelling, but I wondered, Bob, do you not use a PowerPoint or any physical evidence in this case because the document may be against you, or is it just your matter of your style?
No, I mean, in the opening, so this was a federal jury trial. And it was actually a case that Jeff Eisel and Jay Fleece, I believe, had tried. There were several cases and an appeal in between, and then it turned into a federal case. And then they asked me to take the case over. We had 20 minutes for the opening. I had 15 minutes to deal with 18 jurors. I had 15 minutes for voir dire. So this was all speed dating. I still wound up wiping out, a lot of the panel. In the trial itself, the documents were blown up, on the wall in the federal court. I operated most of the trial with an iPad that controlled what was being seen. So the medical records, the jurors at one point had a note saying, hey, he said in the opening that she was 6'2". We haven't seen that. The judge passes the note to us. Next witness, I get up, I flash it up there. There's the medical record, 6'2". Okay. And so technology was used, but in the opening, I felt it was important to tell them the story. And the big issue is when I talk to trial lawyers who don't know anything about trust, they don't remember what a trust is. They don't know what it is. So I actually worked with some lawyers in Los Angeles, and they said, how can you make it concrete? How can you concretize this? I said, I'll use a box. So of course, everyone understands what a box is, and you can take any abstraction and make it concrete. So a famous example, Jerry Spence, who's a lawyer that I've known for many years. I'll give you an example. He had a case where he's defending, and the other side said, that it was a defamation case, and the other side said, well, half of this is true. And Spence said, well, a half truth is like a half a brick. When you throw it, it goes twice as far. Okay. That's an example of taking an abstract concept and making it, concrete. So I do use PowerPoints in openings. This was one where, because it was only 20 minutes, okay, and I wanted to touch the jury, I decided I'm just going to keep my eyes on them. I'm not going to distract them with documents. They're going to be getting a whole week of that.
Okay.
Time restraints.
I thought you did a great job. In the sense that when you have a complex case with a lot of documents, it's very important to give the jury a simple theme at the very beginning that they can follow, to give them the cliff notes of what the whole story is. And I thought that was very good. I think you would have gotten bogged down in your opening if you'd had if you were flashing PowerPoint and things like that, because the story was so complicated and would have taken so long to tell.
Yeah, it was a very complex story. And, if you have a car wreck, it occurs here, or you start at the bar and then the guy wrecks some people's lives here. This was, we had a case going on in New York. We had action in Clearwater. We had stuff going on in Oklahoma at the home, stuff going on. So we had multiple places, multiple scenes to deal with, and two pieces of, litigation, going on. I just let me just tell you one thing. When I said that Robert is a piece of bread in the opening, that was because I wanted those jurors to know that he's not ambitious and he's not a threat. Why did I do that? We did a focus group on this. And here's what I told him. If you don't do a focus group, you're not going to know what ordinary people feel about things. They're not distorted like us. I simply told him this. Actually, it was Zach Zorwest, my partner, who handled it. And we sat there in plain clothes and we had this focus group. And we told him the story. These two granddaughters following their father's instructions and wishes, grab a hold of their grandmother's estate, make it so she could never touch it again. And we gave the background that she lives with Robert. A bunch of the people in the focus group started saying, well, maybe these girls were protecting the assets from Robert. Their mind was starting to fill in facts based on their own experiences and based on their own impressions. And so I felt it was important to cut that off in the opening before they went there, because they're trying to figure out, why would these girls do this? They also want to know, where's these girls' mother? How come she isn't, where is she in all of this? How come they haven't stopped her? Okay. So once I learned those things, and then when Shireen says I did use the language of the people, but also you get the language from the focus group. What are the words that they are using?
Mhm.
They're going to understand this concept of a trust being in a box. So that helped. I will show you, this is part of the transcript. In my opening, I didn't say that, you tell my brother I'm going to butt F you as hard as I can. Why? Because there was an issue about whether that was going to come into evidence. And if you really want to lose credibility, proclaim something in your opening and then it doesn't come out. And then in the closing, what is your opponent? He's going to get up on his hind legs and say, look at what he did. So here, if can you see the transcript I put up?
Not yet.
How about now?
Yes.
Okay, so listen, we had a big evidentiary battle about this before I put it up. Federal Judge Virginia Covington is like, how is that not hearsay? I said, it's not offered for the truth of the matter asserted. Okay. I almost said inserted because, you're dealing with this. And the other side claimed that it was. The judge asked us for cases. We gave her cases. She agreed that it wasn't. And then then I was able to do this. She even told the jury that I was right about it because we had ended the day with the objection. She says, I'll let the jury go. We'll rule on tomorrow. And it says, what did he say to you? And when you get to the F word, will you just say F instead of the whole word? Why? I mean, we're in court. We got to show respect. And this is the son-in-law saying, okay, he said to me, and I've never seen Joey act like that. He was screaming, he was cursing, he was very upset. He said he flipped it back. He's talking about the judgment to the other page. And he said, you tell Robert because he lost the family fortune, I'm going to butt F him as hard as I can. And so key thing, when you have an opening statement, and this is for civil lawyers, you're not sure it's going to come in. You got to be very careful. What I understand from criminal defense lawyers and some of the best ones around the country, including Jerry Spence, he tells the whole story. He tells the whole story, and he tells the story as if his client will testify because he says, I haven't made that decision until later in the case. And right now I'm going to tell him everything I know about the story. But I am cautious in the opening. I'm only going to put on stuff that I'm rock solid about. There was another issue that came up in the middle of this trial where there was a question. So I said, what did he ask you to do? This is what I'm asking the witness. What did he ask you to do? Objection, hearsay. And we had to show the judge. We showed the judge the cases on. We anticipated it. We had cases. Questions are not hearsay because it's not an out of court assertion. So if you say, what time is it? That doesn't assert anything. Of course, you can have a question that says, when you murdered Louisa and hid her body behind the 7-Eleven, what time was it? Well, there's an assertion built into the question. So we had these evidentiary things. And of course, we knew what the testimony was going to be. We knew what the witnesses were going to say. We anticipated it. And we had the case law ready. This particular judge loves case law more than the federal rules of evidence. She wants to see specific cases on it. So again, you'll note with this opening that I'm not talking about the law. I'm telling them a story. I want them on my side. In other cases, and especially in a case where you know what the law is and the judge has already decided what the jury instructions are going to be in advance, put it up there. You know, show them this is the key. This is the area that we're going to be dealing with. In this case, it was pure storytelling. And it was largely chronological, with the exception that at one point, I left a little mystery. She's sitting out there. How did this trust ever get executed? I tell you at the end, we flash back that the lawyer went ahead and swapped the 2 pages. It was actually Jeff Eisel's firm. Jeff and Jay Fleece that figured that out.
It was a great depo. That was some great evidence.
Interesting. Well, Bob brought
If I
up,
can chime in,
please.
I was going to add, I think that element and the switch, by putting that at the end, keeps, like, it does a couple things, but I think it keeps the jury on pins and needles, like, wait, we want to know what happened. We left and there's an old lady sitting outside of a door. And then you come back and you're like, oh, by the way, they took her signature and they just put it over here. I'm guessing it was an electronic signature from like a DocuSign or something. But it just really, it stops and makes you think, like, how in the world? And it kind of gives the jury a finality that I think, where they're like, ooh, we're really intrigued in this.
You know,
And I think it worked really well.
lying is the #1 sin in the courtroom, but close second is boredom. If you bore the jury, you ought to be shot. So you have to build in something like that. What they did was they simply pulled the actual signed document from the revocable trust, and they attached it, they stapled it to the irrevocable trust. It was that basic. It wasn't, we're going to move this signature electronically. There was no skill in it. So and Karina and I were talking about this on how you do things. Sometimes your opening is chronological. Sometimes your opening is by issue. And sometimes you blend them.
Yes.
And one of the things I say all the time is there is a best way to do things. And you have to tailor it for each case. And we try and do that, and we mix and match things. But I am a believer that it is the story that the people remember. It's the story where we are programmed to hear once upon a time, and then here's a story. Okay. And that's what resonates with humans, as opposed to, I'll just very quick digression. I'm in Tampa. There's 15 lawyers in a conference room. One's called in from Minnesota. And the lawyer from Minnesota says, Your Honor, I don't think section 63.805, so just kept going. She gets done. It was Judge Arnold, not St. Arnold, but Judge Arnold, retired in Tampa. And he looks at us and he says, will someone tell me what this case is about? Okay. So what do we want to do? We're giving them the context. What has Olga done wrong in any of this? Not a darn thing. Not a darn thing. But we had to inoculate Robert so that the jury didn't let their minds start thinking, I bet you he was up to something, and these girls, instead of being villains, were heroes.
Bob, how did defense counsel respond to your opening? What did they do?
They played it this way, okay? And I had a very good defense lawyer on the other side. And he did a scripted opening. He basically read his opening, and that reads great on appeal. But you know, the eye contact, he even missed something in voir dire. I was asking one of the jurors, hey, I haven't heard from you. One of the problems in this case is, how do you feel about family suing family? Okay. And I see this juror in the back, she hadn't said a word. I said, how do you feel about that? And she goes, we're good. Well, he's got his head down taking notes. You got to look at the jury and have somebody else take notes on voir dire. Okay. So what he did in that was he did say Robert, he did try and pin the tail somewhat on Robert, but there wasn't much evidence. But he raised doubt about Robert's motives and what he was really up to, that Robert really wasn't so pure. He also said, hey, you know, there was a lawyer, she's board certified lawyer. She's a member of ACTEC. She's in Tulsa, Oklahoma. You know, she did this and she saw it all and she explained it to Olga. I mean, they relied heavily on her testimony. I deposed her in Oklahoma, and they played all of her testimony for the jury. And let me say this. I was a complete and total gentleman, and you should be. Okay? Because I knew that that whole thing was going to be played. So all of a sudden, there's an objection at one point from opposing counsel. At one point, we were deposing a third party in Oklahoma, and this woman says, you know, I've let you get away with a lot, but, you know, I'm going to start objecting to this. And I say to her, if you have a legal objection, let me know and I'll try and accommodate you. All of that got played to the jury. All the judges hearing it, the jury's hearing it, that I am as nice as can be. I've got the sympathetic person here. I don't need to come on as a villain. I was as nice as I could possibly be, especially because with this lawyer who did that, you know, I wanted to cut her head off and mount it on a stick and march up and down the streets of Tulsa to say, you know, this lawyer shouldn't be practicing. You can't perpetrate this kind of a fraud. They were careful not to blame her for anything. They didn't say, well, she had her lawyer and that's what she did. But they relied on the lawyer who came in and tried to say that Olga knew what was going on, even though she couldn't see, even though her hearing was impaired. I'll tell you how bad her eyesight was. When my client Olga gets put into the witness chair, she's facing the back of the courtroom. She's not facing the judge. She's not facing the jury. And I get up to the podium and she's still staring at the back corner. I said, Your Honor, do you mind if I orient her? And the federal marshal female came over and spun her around. She could not see anyone. She could not make out me. She couldn't make out the jury. And she had to have headphones on. When they went to swear her in, they're saying, would you raise your right hand? And she's not doing anything. So I said, Your Honor, she can't hear. They had put headphones on her. Would you raise your right hand? She raised her right hand. The jury was seeing her impairment right there. It was all on display.
Bob, you said that opposing counsel had a very scripted opening for this case.
Yeah.
But in this case, or even generally in other cases, do you think that the defense opening should somehow, that they should change their plan or whatever they had, you know, in mind, what they were going to present based on what plaintiff presents in their opening?
Yes.
Yes. You have to choose your own order. You have to choose what is best for you. You don't want to follow the other side's order. And let me just tell you what happens all the time. You get done, and the last point you make, then the defense gets up and they want to talk about that. And that can be effective, but a lot of times what you're doing is you're being defensive and you're reacting, and now you're not telling your story. And now you're not, you know, you're not presenting the facts the way you want to present them. You're reacting to what I do. And when Shireen says, anytime I have a defense lawyer that talks about the burden, which you have to, for me, when I'm the plaintiff's lawyer, it's as if they're afraid of what I just said. When they say, listen, what lawyers say, the judge is going to tell you isn't, you know, this isn't test, this isn't facts, this isn't evidence. What I hear them say is, I've just been hurt by this opening, and I'm hoping that you'll disregard some of it. So, you know, obviously there are many, many ways to do the opening. I don't write out openings. I will have bullet points. I will look at them before I get up there, and then I try it without notes. If I forget something or there's a problem, I can always go back to the podium and take a quick look. But the eye contact, the connection, seeing the reaction is worth more than being precise. Because why? Because I want the jurors to think I'm like them. I'm using their language. I'm talking like them. If I go in and I'm using stilted language and big terms and everything else, what am I doing? I'm distancing myself from them. I want to create a tribe, and then I want them to select me as the leader and have them say, this is the guide. This is the guy that's telling us the truth. And incidentally, if you have weaknesses in your case, you want to try and bring those out. And this is what Shireen and I talked about. We both do this. Before we do an opening, we do our opponent's opening. We anticipate where they're going to go so that they don't come in and do exactly what Shireen says and say, you know, Mr. Prasante's opening was great. Not so much for what he said, but for what he didn't tell you. Okay? He didn't tell you this, and he didn't tell you this. And you remember he mentioned that, but he didn't tell you this. You sit down and do your opponent's opening, and it does two things for you. Number one, it gets you to look at the case more objectively, because they're going to get on their hind legs and they're going to have something to say. What is that opening? Figure it out. And then try and gun it down in your opening without ever referencing that they're going to be doing that. Okay. What it also does is it gives you confidence, because if you haven't thought about what their opening is, when you hear it for the first time, it can rock you when you're sitting in counsel chair. You're like, geez, I'd never realized she's put this whole thing together. They've got this angle I never even thought of. Okay. Oftentimes, the most wonderful thing I hear when I'm in a trial is one of my partners will say to me, your opening for them was better than theirs. So I say, hey, they missed this point, they missed that point, they weren't effectual, they're reading, they're behind. And that's the way, that's the way to go. I play chess, I'm a chess master. It is easier for you to see what you can attack than it is for you to defend. We see what we can go attack, but it's difficult for us to see the defense side of it. When you do your opponent's opening, now you're in their skin. Now you're saying, okay, I've got a problem here. I know Bob's going to do this powerful opening. What's the antidote? What's the best way to go? Okay, huge mistake in the middle of this trial. You've got a woman who's 90-something years old, and you cross-examine her for 8.5 hours. Okay. The jury hated it. The next day, my client couldn't even come to the federal courthouse. So I tell a federal judge, I'm sorry, Olga, yesterday was too much for Your Honor. She can't be here today. We're hoping she'll be back by the end of the week. Would you tell a jury? Judge Covington says, you tell the jury. So I stand up when the jury comes in and I tell them that. Next day, I said, we're hoping she'll be back before the end of the week. Next day, 10:15 break, judge says, we have a note from the jury. How is Olga doing? Okay. So Judge says, Mr. Cristante, I said, she's home resting, and again, we're still hoping she can make it back here.
That's usually when the case settles.
Just
But
one day.
to go back to your question, which was, do you adapt and change to what you just heard? And so I guess it is a blended answer. Don't let the other side get you off your game, but also respond. Shouldn't be in a situation where you've kind of your confidence is in the gutter and you're throwing out everything you've worked on. But you should incorporate what you just heard and use the words that Bob just used. Take notes. And I do that, whether, it's the most effective in rebuttal, right? That's like the most fun. You just heard opposing counsel say A, but he forgot to tell you about B. What about C? And if you can use their words, it brings them back. So if Bob scored points, you can now score some points. So that's, I guess, probably the better way to answer that is don't let them get you off your game, but you should respond and use their words when you're responding.
What about, I know this case was in federal court, but I know the majority of our members practice primarily in state court. Would there have been anything different about this opening that you would have done in state court? For instance, I know, there was an issue with the language, and you said we have to be respectful of the court. And I think that it's probably everyone's opinion and impression, because it's pretty much a fact that federal court is a little more tight-laced than state court. I'm not saying would you have said the full F word in state court, but would maybe there have been like a hand gesture with it in state court? Or like, would nothing have changed? You just would do what you do. Do you
On
change
that-
anything depending on what court you're in?
So first of all, I have my own way of doing things, and I don't change based on which court I'm in. You always have to show respect for the court, and you have to show respect for that jury, and you don't know who's going to be offended by you using that word. So what happens is you look like a gentlewoman or a gentleman by saying don't say the word. They know what the word is. You're being respectful of them. Okay. That's the number one thing. The number two thing is what would have been different. Most state judges would have given more time for an opening. And I like to have more time for an opening. But the reality is, Winston Churchill once said, it takes me 10 minutes to do a 2-hour speech and 2 hours to do a 10-minute speech. Because the federal judge constrained us to 20 minutes for the whole opening. This opening was 30 minutes. I had to be even more efficient there. You have to be absolutely efficient in doing it. In state court, they usually say, Bob, how long do you need for opening? There have been federal judges like Judge Whittemore. I think I had 6 jury trials with him. He had one rule on openings. How long do you have? As long as you want to hang yourself. And he believed that if you spent more than 45 minutes on an opening, you were done because those jurors weren't listening anymore. And I would say, I agree with him to an extent. If you are boring them, you're dead. You have to make it riveting. You have to keep them, and you have to build in some of this. Why is this happening? And you can do that with your line. You can say, we're going to come to that, and you're going to find out what happened. Their minds are starting to fill those things in, and I'm fine as long as they don't head in a direction I don't want them to go in. There are differences between state and federal court and how things are done. And let me just say that the federal courthouse is generally empty. There's federal marshals all over the place. It's surrounded by cars. It's an intimidating place for jurors to show up at, for witnesses to show up at. It's just, the whole thing is much more imposing. Okay. But as far as me, I'm the same wherever I go. Now, do I have to adjust things for the judge? You bet your life. If you have a judge who knows the rules of evidence and is precise and so forth, and wants you to say that's 803 or that's, whatever it is, 404B evidence, you have to be right on top of that. You have other judges that are different than that. Let me give an example. Judge Covington really doesn't restrict evidence very much on relevance. She says, you're professional. I'm going to basically let everything in unless it's really out there. Where is she really restrictive? On hearsay. She has a very narrow view on hearsay. And so knowing that, we had to have our research lined up, because all these statements that I'm talking about that might get objected to, I had to be ready for that. So you want to know how tight the judge calls the case. And that's invaluable, because these objections are right in front of the jury and you want to win those. We went through the whole trial. There was one ruling against us, basically. The rest of them went our way. And twice she told the jury that. One time she says, Mr. Prasante is absolutely right. I didn't know a question couldn't be hearsay. She says, I still remember taking evidence in law school. It was an excruciating course. And she says, this stuff is not easy. Well, she's there listening to the trial, and then she's got 2 staff counsel, 2 lawyers who are listening to the trial, and they're typing and sending her notes. So I don't have to hand her a case. I say 53 Fed 3rd 44, and they're researching it, and then they're sending messages up to her saying, he's right, this is not hearsay. And then all of a sudden she stops the trial. Mr. Prasante, remember that question you're going to ask? You're right. You can ask it.
So has anybody had a trial where, when they were defending and they had to deal with Fabre defendants or empty chair defense? So when and if that occurs, it's pretty common in civil cases, whether it's a car accident case, there's somebody else who's responsible there, the light, the street, the signs. Or, just someone who wasn't sued and played a part in the negligence, that can be a very powerful an opening on the defense side. And that can go right into, what Bob told you, but what he didn't tell you was about Mr. Smith, and that Mr. Smith caused X, Y, and Z. And that's a really great way to kind of hijack the story. If you have that, if you are pleading a Fabre defense or you've got an empty chair defense, so to speak, and it's worth a darn. If it was worth pleading, hopefully it is worth a darn. I think you go right into it, an opening, and I think that can be pretty effective.
So we're, that's true. And in guys like Jerry Spence, they've done that where they'll actually pull a chair out, like in closing. He had a case against Penthouse. It was a defamation case, and he pulls a chair, Bob Guccione. Where are you, Bob? He'd actually start talking to the chair as if Guccione's there. Things like that. He's gone. All right. So okay, so in case you don't know it, well, Shireen and I are good friends, and we've had many, many cases where we're on the same side, where we're co-counsel. So if you say, geez, she hasn't been too critical of Bob, it's for that reason, because she certainly could be. And if you ever want to have the best co-counsel to deal with, it's Shireen. Okay, phenomenal worker, trials. She had a $16 million case on a escalator where a little girl, lost a finger, and just about any kind of case. Shireen is fantastic, and plus she teaches trial advocacy at Stetson. So it's when we talk to each other, we're talking the same language. We've both been there. We both have a lot of experience. I wanted to mention one funny thing, Jeff, and I don't know if Jay Fleece told you this. So Jay Fleece is testifying in this federal trial. And if you don't know Jay, Jay's a great trial lawyer, practiced probate, guardianship litigation. I've known him for many years. He used to be with Holland and Knight, and then he was with Hamden Baskin, another great lawyer. And now I think Jay's out on his own. And opposing counsel makes this mistake and says, while Jay is on the stand on cross-examination, if you were handling the state court action, why did you bring Mr. Persante in? And Jay says, well, because I really don't practice in federal court, and Mr. Persante has vast experience there. I felt like going up and paying opposing counsel for asking the question. Okay? Why would you ever ask him that question? Okay.
And is this all of these trial?
This is in the middle of the trial. This is right in front of the jury.
What does that have to do with anything?
Yeah, I think he was hoping that Jay would say, well, I lost confidence in the case, or I didn't believe in it, or you tell me what answer he thought he was going to get. It's like it's like asking OJ to try on the glove.
Yeah.
It was not a good decision. Not a good decision on his part. So just talking about openings, Judge Burgess mentioned themes. I struggle with themes because I'm not, if the glove doesn't fit, you must have quit. I'm not sing-songy, and there aren't a lot of analogies that I like. In this particular case, I think it was Tolstoy who wrote that happy families are happy for the same reason, but unhappy families are unhappy for different reasons. And I thought that fit this case. That's about as close as I get. The theme could be almost anything. It could, if it's a distracted driving case, you can throw that in and throw it in and repeat that word as it goes through. And then you repeat that theme in your questioning. But the very hardest thing for me in any case is the opening line. How am I going to approach this case? Now, I can tell you at the Trial Lawyers College in Wyoming, they are big believers in putting the black hat on the defendant first. Before, it used to be, let me build up my client and let me have them love my client. And, all the persuasion is the same as it's been since Aristotle, ethos, pathos, logos, okay? And ethos is, the credibility, and pathos is the emotion, and logos is logic. And so what they believe there, they look at, I don't know if you know the story Tombstone. In Tombstone, what happens is it starts off where these bad guys go in. There's a wedding with Mexicans, and they go in and just shoot the groom. They wind up just trashing the whole place, gunning people down needlessly and heartlessly. And then what happens is, the sheriff, a Wyatt Earp, okay, then guns these guys down one by one. All right. Well, and I think Kurt Russell was the sheriff in the case. Well, what happens if you started the story with Kurt Russell just gunning all these guys down? You're thinking, well, wait a minute, this is some lunatic cop. So I started off by talking to them about the fact of what they tried to do to their grandmother, that they were greedy, and you're going to hear the whole story about it. And then I phased into talking about, now let's talk about, my client. So when you make that, how are you going to start? Are you going to try and pin the tail on them to begin with? Or are you going to try and build up your side first, which is the other way to do it? It's a beautiful sunny day. Little Johnny has now this is his 7th birthday. Life is wonderful. All's well with the world and God is in heaven. And he pulls out and he gets crushed by a truck. You can do that. That has shock value. In the kinds of cases that I handle, which deal with fraud, undue influence, securities violations, I tend to try and put the black hat on the defendant in the beginning and do it with facts as opposed to adjectives. And also notice I was pretty measured when I was talking about what happened. If I come in and start screaming and yelling, what happens then? The jury recoils and they're not feeling it. Okay, I'm the one that's feeling all the emotion. I'm the one that's raising my voice. I'm the one that's outraged and all of this other stuff. What you want to do is give them the facts and get them outraged. Have them experience it. Because once you start yelling and once you start talking about how horrible this is and you're throwing around adjectives, and then they're not experiencing it. They're watching someone else who's upset, and they're not where you are. You're upset because you've had to deal with this creep lawyer on the other side. You've been through all these discovery battles. They've been misleading. The witnesses have been deceptive. They've withheld documents. You go in angry. You got to lose that because that jury is not there. You need to slowly turn up the temperature. You need to help them to feel what you've been experiencing, as opposed to making it about yourself and going in about your own outrage. It all becomes about you. You want them to hear the facts and for them to be upset. I think Hemingway said the shortest story ever, baby shoes for sale, never been sold. Now, you're already feeling some emotion here. What happened to this baby? What, this is, it's a short story and it's already horrible. So, and is he saying anything? Let me tell you this horrible story about things that happened. No. So the way I try and do the opening is to get them, by hearing the cold hard facts through the story, to get them to begin to have feelings without me telling them what their feelings need to be or describing my own feelings or my own outrage. You got to make it about the audience and not about you.
Good point. I think that advice goes even for bench trials. We spend hours and hours with opposing counsel, and sometimes it's one of those cases where, you do get angry about how the case has been handled. And so if you go into a hearing and you bring that, and you're not just factual, then I think the reaction of even judges are going to be like, why should I accept this? She's obviously too emotional about this. I need to step back. And, you know, I have to remind myself of that. You have to tell people the facts that they can accept at that time. And you have to describe it in a way that they can accept it at that time. They don't know you. They don't know your client. They don't know the other side. All they know is they have a job. And it's the job that the judge has given them. And that is they got to listen to both sides and make a decision. So pounding too hard, squeezing too tight, you know, might feel natural because you're there, but it's not natural for them. And of course, they're the only ones that matter.
I was going to mention something. If you notice in the video, of course, I don't have my client there. Olga has since passed away. I'd like to, physical contact is important. I like to be able to put my hand on my client when I introduce her. I didn't do that with Olga. She was seated, but I did walk over towards her. Make sure your client knows you're going to do that before you walk over and then just touch them. I've seen people jump out of their skin. Okay. All right. You have to say to her, listen, I'm going to do my opening. I'm going to walk over and I'm going to put my hand, just gently touch your shoulder.
Don't do it, Joe Biden on him.
So, yeah, don't just, you know, a friend of mine did that. It was a bench trial. Our client is sitting there. It's in the middle of the trial and he walks over and touches her on the shoulder and she screams. I turned to the other side and I said, would you take him over on your side, please? Don't touch people unless and until you got to get their permission. And then you have to say, I'm going to come over and I want to show, you know, if criminal defense lawyers, if they've got someone, you know, you got the jury, what do they see? What do they see? That this lawyer cares about this client, that this lawyer went over and touched this client, and that there's a connection there. This isn't just a mouthpiece.
Mm-hmm.
What they see happening impacts them. I want to just throw in one quick war story. Case up in Pennsylvania. It's a racketeering case. And one of the guys that's been swept up in it is a Florida guy. So he gets a Pennsylvania lawyer, but he asks his local counsel, great lawyer, have any advice for me? He says, yeah, before the case starts in the morning, outside the courtroom, you know, when the jury's coming in, the jury's coming out, don't have anything to do with the other guys. It's like 30 defendants. On the breaks, all the rest of the guys are outside smoking cigars. Hey, Vinny, they're all hugging each other and everything. Halfway through the trial, the guy calls up the lawyer here in Florida and says, hey, the jury's noticing I'm never with them. He was the only one acquitted because he wasn't with the group. So all of those little signals pick up. You have to care about your client and it has to show. And in this case, I was trying to show, look, I've carried Olga this, I did in my closing, look, I have taken her this far. You know, she's remarkable at her age to fight this battle. And now she's in your hands. You know, this is the empowerment. I'm handing her over to you. Now, who wants to disappoint this 90-year-old?
Okay. So any other questions before we have to sign off here?
Bob, something I'd like to add. My practice has been to talk to the jury after the trial. Once they've rendered their verdict, I go back and I talk to them and I ask them about administrative things, but I also ask them about their feelings about the lawyers and the arguments and so on and so forth. And the reactions that I've gotten from all of the juries I've talked to are parallel and reinforce what you had said. They don't like theatrics. They don't like people. They don't like angry opening statements. They just want to get the facts. They want to be able to do their job. They want to understand what the case is about at the outset and get on with it. So I can tell you based on my experience with state juries that validates what you were saying.
Thank you, Judge.
Mhm. Anybody else, comments or questions? Experiences? Tips? How about from this cute little one over here? Mr. Walsh's young one. Hi. So, we're good.
Well, thank you, Bob. It was a great presentation.
Very
Thank
good.
you, Your Honor. I appreciate it. And I wanted to thank Judge Burgess again for the fantastic job he did on the Zoom across the Atlantic. That was a great experience. I think it was well received. And I don't think I told you this, but I kind of Googled it and stuff, and I found that it was advertised at least one of the inns in England. In other words, it was pretty good, and I'm glad to hear it was well received over there.
I get requests to do it again on a regular basis. So you may be cast as a member of the Zoom gang to come back on and do it again.
With a wig, I hope.
Okay, are we done, Clarica?
Yes, well, thank you. I wanted to thank Bruce Denson, actually. This idea for this presentation today was his brainchild, whether he forgot about it or not. But I saw the head shaking. But it was Bruce's idea, and so we ran with it. So I hope we did your idea that you forgot about proud, Bruce. But thank you, Bob and Shireen, for putting all your hard work into this presentation tonight. And thank you, everybody, for joining us and for staying a little later. But, you know, we're never just going to cut off conversation when it's going well. Again, next meeting is March 25th. Put it on your calendar. I'll probably send out the Zoom invite maybe tonight, just so I don't forget. But the more the merrier. Like I said, we'll be having everybody in assigned pupillage groups, and icebreakers are like the bane of my existence. So I promise that there will be no icebreakers in your smaller breakout groups, but there will be discussion and interaction and stuff like that. So that's it for tonight, and we'll see you next month.
Very good. Thank you. Thank you
Thank
very
you.
much for your
Say
work.
bye to everybody.
Thank you. Good night.
Thank you. Good
Bye,
night.
Emma.
Night.